Greetings, my fellow freedom lovers and sovereign thinkers. This is LL3's newest podcast. My name is Craig, and presiding within the beautiful swampy mangroves of South Florida. Today is Saturday, March 29th, 2014. Early Saturday morning, that is. Just browsing around, deciding what I want to narrate and give my viewpoints. So, I was really want to talk about the first thing. It's from govtrack.us, and it's Senate Bill Free Flow of Information Act of 2013, which is Senate Bill 987. And this is a pretty controversial bill, and when I'll address this and explain why. So, I will start. Senate Bill State 987, report number 113-118, in the Senate of the United States, May 16, 2013. This bill was originally authored by Mr. Charles Schumer himself, one of my favorite servants in our irony way. Plus, you have co-sponsors, you got Senator Graham, Senator Tester, Senators Klobuchar, Harkin, Bennett, Murray, Udall, Baucus, Cantel, Boxer, Isakon, Baldwin, Blumenthal, Blunt, Gillibrand, McCaskill, Coons, Harirano, and Leahy introduced the following bill, which was read twice and referred to the Committee on the Judiciary on November 6, 2013, reported by Mr. Leahy with an amendment. A lot of this stuff is struck down, but it says here, a bill to maintain the free flow of information to the public, providing conditions for the federally compelled disclosure of information by certain persons connected with the news media. A lot of this has been striked out, so I'm going to have to go down just a little bit here until I find some light. And then right here. Okay, Section 1, short title. This act may be cited as the Free Flow of Information Act of 2013. Section 2, compelled disclosure from covered journalists. A condition for compelled disclosure in any proceeding or in a connection with any issue arising under federal law. A federal entity may not compel a covered journalist to comply with a subpoena, court order, or other compulsory legal process seeking to compel the disclosure of protected information unless a judge of the United States in the jurisdiction where the subpoena, court order, or other compulsory legal process has been or would be issued determines, after providing notice and an opportunity to be heard to such covered journalists. Subsection 1, that party seeking to compel disclosure of the protected information has exhausted all reasonable alternative sources other than a covered journalist of the protected information. And 2, that A, in a criminal investigation or prosecution, I, if the party seeking to compel disclosure is the federal government based on public information or information obtained from a source other than a covered journalist, there are reasonable grounds to believe that a crime has occurred. Subsection 2, based on public information obtained from the source other than the covered journalist, there are reasonable grounds to believe that the protected information sought is essential to the investigation or prosecution or the defense against the prosecution. Yeah, I know I said I in the very first one, but it's subsection 1. Subsection 3. The Attorney General certifies that the decision to request compelled disclosure was made in a manner consistent with Section 50.10 of the Title 28. Code of Federal Regulations if compelled disclosure is sought by a member of the Department of Justice in circumstances by govern. Section 50.10 of the Title 28 Code of Federal Regulations and subsection 4. The covered journalist has not been established by clear and convincing evidence that disclosure of the protected information would be contrary to the public interest, taking into account both the public interest in gathering and disseminating the information or news at issue and maintaining the free flow of information, and the public interest in compelling disclosure, including the extent of any harm to national security, or subsection B, in a matter other than a criminal investigation or prosecution based on public information or information obtained from a source other than a covered journalist. Under subsection B, you got 1. The protected information sought is essential to the resolution of the matter, and 2. The party seeking to compel disclosure of the protected information has established that the interest in compelling disclosure clearly outweighs the public interest in gathering and disseminating the information or news at issues and maintaining the free flow of information. And you got subsection B, or B, subsection B. Limitations and content of information, a subpoena, court order, or other compulsory legal process seeking to compel the disclosure of protected information under subsection A shall, to the extent possible, be narrowly tailored in purpose, subject matter, and period of time covered so as to avoid compelling disclosure of peripheral, non-essential, or speculative information. C. Rule of construction for compelled disclosure from covered journalists. Nothing in this section shall be construed to prelude, in addition, or the procedures required under the section. 1. The requirement that a federal or governmental entity shall obtain a warrant for certain communications as set forth in section 2703 of Title 18 United States Code, commonly known as the Electronic Communications Privacy Act. Or 2. The requirements and procedures regarding search and seizure set forth in Rule 41 of the Federal Rules of Criminal Procedure. Section 3. Exception relating to criminal conduct. A. In general, Section 2 should not apply to any information, record, document, or item obtained as a result of eyewitness observations of or obtained during the course of alleged criminal conduct by the covered journalist, including any physical evidence or visual or audio recording of the conduct. B. Exception. This section shall not apply and subject to sections 4 and 5. Section 2 shall apply if the alleged criminal conduct is the act of communicating the documents or information at issues. 4. Exception to prevent death, kidnapping, substantial bodily injury, sex offenses against minors, or incapacitation or destruction of critical infrastructure. 2. Shall not apply to any protected information that is reasonably necessary to stop and prevent or mitigate a specific case of 1. Death, 2. Kidnapping, 3. Substantial bodily harm, 4. Conduct that constitutes a criminal offense that is specified offense against a minor as those terms are identified in Section 111 of the Adam Walsh Child Protection and Safety Act of 2006, which is Title 42, U.S. Code, Section 16911, or an attempt or conspiracy to commit such a criminal offense. Or 5. Incapacitation or destruction of critical infrastructure, as defined in Section 1016E of the USA Patriot Act, which is, Title 42 U.S. Code, Section 5195C, subsection E. 5. Exception to prevent terrorist activity or harm to the national security. A. In general, Section 2 shall not apply to any protected information if 1. The party seeking to compel disclosure is the federal government, and 2. A. in a criminal investigation or prosecution of the allegedly unlawful disclosure of properly classified information, the courts find by a preponderance of the evidence that the protected information for which compelled disclosure is sought would materially assist the federal government in preventing or mitigating 1. An act of terrorism, or 2. Other acts that are reasonably likely to cause significant or articulable harm to national security, or B. Any other criminal investigation or prosecution, the court finds by a preponderance of the evidence that the protected information for which compelled disclosure is sought would materially assist the federal government in preventing, mitigating, or identifying the perpetrator of 1. An act of terrorism, or 2. Other acts have caused or reasonably likely to cause significant or articulable harm to national security. B. Difference in assessing the existence or extent of the harm described in subsection A. A federal court shall give the appropriate deference to a specific factual showing submitted to the court by the head of any executive branch agency or department concerned. C. Relationship to Section 2. Subsection A shall not apply and subject to Sections 3 and 4 and 2. Section 2 shall not apply to any criminal investigation or prosecution of the allegedly unlawful disclosure of properly classified information other than in which the protected information is sought by the federal government or prevent or mitigate the harm specified in subsection A2A, in considering the extent of any harm to national security when applying to Section 2. To such cases, a federal court shall give appropriate deference to any specific factual showing submitted to the court by the head of any executive branch, agency, or department concerned. D. Subsequent unlawful disclosure. The potential for subsequent unlawful disclosure of information by the source sought to identify shall not by itself and without any showing of additional facts beyond such potential disclosure be sufficient to establish that compelled disclosure of the protected information would materially assist the federal government in preventing or mitigating 1. An act of terrorism, or 2. Other acts that are reasonably likely to cause significant and articulable harm to national security. 6. Compelled disclosure from covered service providers. A. Conditions for compelled disclosure. 1. In general, except as provided in paragraph 2 of any document or other information from the account of a person who is known to be reasonably likely to be a covered journalist is sought from a covered service provider. Section 2 through 5 shall apply in the same manner that such sections apply to any document or other information sought from a covered journalist. 2. Exception. Subject to exception. If any government or document or any other information from the account of a person who is known to be or reasonably likely to be a covered journalist is sought from a covered service provider under Section 2709 of Title 18 United States Code, the provisions of Sections 2 through 5 governing criminal investigations and prosecutions shall apply in a manner that such sections apply to any documents or other information sought from a covered journalist in the course of a criminal investigation or prosecution, except that clauses 1 and 3 of Section 2, subsection A2A shall not apply. B. Notice and opportunity provided to covered journalists. A judge of the United States may compel the disclosure of a document or other information described in this section only after the covered journalist from whose account the document or other information is sought has been given. 1. Notice from the party seeking document or other information, such as a subpoena or other compulsory request, not later than the time at which the subpoena or request is issued to the covered service provider. And 2. An opportunity to be heard before the judge of the United States before compelling testimony or disclosure of a document. C. Exception to notice requirement. 1. In general, notice and opportunity to be heard under subsection B may be delayed for not more than 45 days if the judge of the United States involved determines by clear and convincing evidence that such notice would pose a clear and substantial threat to the integrity of a criminal investigation, would risk grave harm to national security, or would present an imminent risk of death or serious bodily harm. 2. Extension. 45-day period is described in paragraph 1, may be extended by the court for one additional period, not more than 45 days, if the judge of the United States involved makes a new and independent determination by clear and convincing evidence that providing notice to the covered journalist will pose a clear and substantial threat to the integrity of a criminal investigation, would risk grave harm to national security, or would present an imminent risk of death or seriously bodily harm under current circumstances. 3. Substantial threat to the integrity of a criminal investigation. For the purposes of this subsection, a substantial threat to the integrity of a criminal investigation exists when the judge of the United States involves finds by clear and convincing evidence that the target of the investigation may learn of the investigation and destroy evidence if notice is provided. 4. Protective orders. For purposes of a determination under this section, the judge of the United States involved shall consider whether providing notice pursuant to a protective order of the covered journalist by mitigate any clear and substantial threat to the integrity of a criminal investigation and any risk of grave harm to national security or any imminent risk of death or serious bodily harm. D. Notice to cover service provider. In all cases in which notice is required to be provided to the covered journalist under this section, a copy of such notice shall be provided simultaneously to the covered service provider from whom disclosure is sought. Once it has received such notice, the covered service provider shall not comply with the request for a disclosure unless and until disclosure is either ordered by the court or authorized in writing by the covered journalist. I like when they say that, covered journalist. Good grief. E. Rule of construction for delayed notice. The delayed notice requirements in this section shall be construed to supersede the requirements for delayed notice set forth in sections 2703 and 2705, subsection A of Title 18, United States Code. 7. Section 7. Sources and work product produced without promise or agreement of confidentiality. Nothing in this act shall supersede, dilute, or preclude in any law or court decision compelling or not compelling disclosure by a covered journalist or covered service provider of 1. Information identifying a source who provided information with the promise or agreement of confidentiality made by a covered journalist as part of engaging journalism, or 2. Records, other information, or contents of communication obtained without a promise or agreement that such records, other information, or contents of a communication would be confidential. Proceed here. Section 8. For review and appeal. A. Conditions for ex parte review or submission under seal with regard to any determination made by a judge of the United States under this act, upon showing of good cause, that judge of the United States may receive and consider submissions from the party in the camera or under seal, and if the court's determined it is necessary, ex parte. B. Contempt of court. With regard to any determination by a judge of the United States under this act, a judge of the United States may find a covered journalist to be in a civil or criminal contempt if the covered journalist fails to comply with an order of a judge of the United States compelling disclosure of protected information. C. To provide for timely determination with regards to any determination to be made by a judge of the United States under this act, that judge of the United States, to extent practicable, shall make determination not later than 30 days after the date of receiving motion requesting the court make that determination. D. Expected appeal process. 1. In general, the courts of appeal shall have jurisdiction, A, of appeals by any federal entity or covered journalist of an interlocutory order of a judge of the United States with this act, and B, an appeal of a final decision of a judge of the United States by a federal entity or covered journalist to review any determination of a judge of the United States under this act. 2. Expedition of appeal. It shall be the duty of a federal court to which an appeal is made under the subsection to advance on the docket of the expedite to the greatest possible extent the deposition of that appeal. 9. Rule of construction. Nothing in this act may be construed to 1. Preempt any law or claim relating to defamation, slander, or libel. 2. Modify the requirements of Section 552A of Title V, United States Code of Federal Laws or rules related to grand jury secrecy, except this act shall apply in any proceedings in connection with any issue arising under the section of federal law or relating to grand jury secrecy. Create new obligations or affect or modify the authorities or obligations of the United States federal entity with respect to the acquisition or dissemination of information pursuant to the Foreign Intelligence Surveillance Act of 1978, which is Title 50 U.S. Code 1801, or 4. Preclude voluntary disclosure of information to a federal entity in a situation that is not governed by this act. 10. Section 10. Audit. A. In general, the inspector of the Department of Justice shall perform a comprehensive audit of the use of this act during the period beginning on the date of the enactment of this act and ending on December 31st, 2016. The audit shall include an examination for each instance in which a court failed to compel the disclosure of protected information under this act and whether this act has created any procedural impediments that have had a detrimental operational impact on the activities of the Federal Bureau of Investigation. B. Report no later than June 30th, 2017. The Inspector General of the Department of Justice shall submit to the Committee on the Judiciary and Select Committee on Intelligence of the Senate and the Committee on the Judiciary and Permanent Select Committee on the Intelligence of the House of Representatives a report containing the results of the audit conducted under subsection A. C. Review no later than 30 days before the submission of the report under subsection B. The Inspector General of the Department of Justice shall provide a report to the General Attorney General and the Director of National Intelligence. The Attorney General or the Director of National Intelligence may provide such comments to be included in the report submitted under subsection B as the Attorney General or the Director of National Intelligence may consider necessary. D. Form. The report submitted under subsection B and any comments included under subsection C shall be in unclassified form but may include a classified annex. 11. Section 11. Definitions in this act. 1. Cover journalist. A. Cover journalist. The term cover journalist 1 means a person who this is subsection AA is or on a relevant date was an employee, independent contractor, or agent of an entity or service that disseminates the news or information by means of newspapers, nonfiction, book, wire service, news agency, news website, mobile application, or other news or information service, whether distributed digitally or otherwise. News programs, magazines, or other periodical, whether in print, electronic, or other format, or other television or broadcast, multi-channel video programming distributor. Such a term is defined under Section 602, subsection 13 of the Communications Act of 1934, which is 47 U.S. Code, Section 522, subsection 13, or motion picture for public showing. Double B, lowercase that is, with the primary intent to investigate events, to procure material in order to disseminate to the public news or information concerning local or national or international events or other matters of public interest, engages or as of the relevant date engage in the regular gathering, preparation, collection, photographing, recording, writing, editing, reporting, or publishing on such matters by AA, which is both, these are capitals, conducting interviews, BB, making direct observation events, or CC, collecting, reviewing, or analyzing original writings, statements, communications, reports, memoranda, records, transcripts, documents, photographs, recordings, tapes, materials, data, or other information, whether in paper, electronic, or other form. Lower cases, CC, has such intent at the inception of the process of gathering the news or information sought, and DD, obtain the news or information sought in order to disseminate the news or information to the public, or Roman numeral 2, means a person who, lowercase AA, at the inception of the process or gathering the news or information sought, had the primary intent to investigate issues or events and procure material in order to disseminate to the public news or information concerning local, national, or international events or other matters of public interest, and regularly conducted interviews, reviewed documents, captured images of events, or directly observed events, lowercase bb, obtain the news or information sought in order to disseminate it by means of a medium set out to subclause 1, lowercase aa in the section, and cc either. Both capital letters AA would have been included in the definition in subclause 1, lowercase aa of this section, for any continuous 1-year period within the 20 years prior to the relevant date, or any continuous 3-month period within 5 years prior to the relevant date. Capital letters BB has essentially contributed as an author, editor, photographer, or producer to a significant numbers of articles, stories, or programs or publications by a medium set out in subclause 1 AA, lowercase that is, of this section within 5 years prior to the relevant date, or capital letters section CC, was a student participating in a journalistic medium in institution or higher education, as defined in section 102 of the Higher Education Act of 1965, which is 20 U.S. Code section 1002 on the relevant date. Okay, go here. 2. Include the supervisor, editor, employer, parent company, subsidiary, or affiliate of a persons described in subclause 1 or 2 or subclause subsection 1, and 3 does not include any person or entity. Subsection 1, those principal functions as demonstrated by a totality of such persons or entities' work is to publish primary source documents that have been disclosed to such person or entity without authorization, or 2, who is reasonably likely to be lowercase aa, a foreign power or agent of a foreign power, as those terms as defined in section 101 of the Foreign Intelligence Surveillance Act of 1978, which is, Title 50 U.S. Code 1801, BB, lowercase, a member of the affiliate of a foreign terrorist organization designated under section 219, subsection A of the Immigration and Nationality Act, which is Title 8 U.S. Code 1189, subsection A, lowercase cc, designated as a specially designated global terrorist by the Department of Treasury with under Executive Order 13224, which is 66 Federal Regulations 49079, lowercase dd. A specifically designated terrorist, as that term is defined in section 59.311 of Title 31 Code Federal Regulations, or any successor thereto, lowercase EE. A terrorist organization, as that term is defined in section 12 subsections A3B62 of Immigration and Nationality Act, which is 8 U.S. Code 1182, subsections A, subsections 3, B, 6, and 2. Lowercase double ff, committing or attempting to commit the crime of terrorism as an offense is defined in section 233, 2331, subsection 5, or 2332, section B, subsection G5 of Title 18 United States Code. GG, committing or attempting the crime of providing material support at that term is defined under sections 2339A, subsections B1 of the Title 18 United States Code to a terrorist organization, or lowercase hh, aiding, abetting, or conspiring in illegal activity with a person or organizing defined in items AA, lowercase AA through subsection GG. Okay. All these little, good grief, man. Let's keep going here. B, judicial discretion. In the case of a person that does not fit within the definition of a covered journalist described in subclause 1 or 2 of paragraph A, I, or 1, a judge of the United States may exercise discretion to avail the person of the protection of this act if, based on specific facts contained in record, the judge determines that such persons would be in an interest of justice and necessary to protect lawful and legitimate news gatherings activities under the specific circumstances of the case. 2. Covered service provider. The term covered service provider means A, any person who transmits information of the customer choosing by electronic means. B, telecommunications carrier or information service as defined in Section 3 of the Communications Act of 1934, which is 47 U.S. Code Section 153. C, an interactive computer service or information content provider as defined in Section 230 of the Communications Act of 1934, 47 U.S. Code 230. D, a remote computing service as defined in Section 2711 of the Title 18 U.S. Codes. E, electronic communication service as defined in Section 2510 of Title 18 United States Code. Or F, any commercial entity that maintained records related to a covered journalist. 3, document. The term document means writings, recordings, or photographs, as those terms defined by Rule 1001 of the Federal Rules of Evidence. Alright, which is United States Code Appendix, 28 U.S. Code Appendix. 4, federal entity. The term federal entity means an entity or employee of the judicial or executive branch or an administrative agency of the federal government with the power to issue a subpoena or issue other compulsory process. 5, judge of the United States. The term judge of the United States includes judges of the Court of Appeals, district courts, Court of International Trade, and any court created by act of Congress. The judges which are entitled to hold office during good behavior as defined in Section 451 of Title 28 United States Code. 6, properly classified information. The term properly classified information means information that is classified in accordance with any applicable executive orders, statutes, or regulations regarding classifications of information. 7, protecting information. The term protection information means A, information identifying a source who provided information under a promise or agreement of confidentiality by a covered journalist as part of an engaging journalism. Or B, any records, content of communication, documents, or information that a covered journalist obtained or created. Subsection 1, or what the hell, 1, as part of an engaging journalism, and 2, upon a promise or agreement that such record, contents of communication, documents, or information would be confidential. 8, relevant date. The term relevant date means that the date which protected information was sought, obtained, or created by the person asserting protection under this act. That was reported with the amendment November 6, 2013. Just to let you folks know, there's another bill similar to that. Same title, Free Flow of Information Act 2013, which is H.R. 1962. I'll be very honest. how this bill is explaining. They want to make journalism a right, not a privilege, rather than a natural born or God-given right. And I know I've talked about in my past episodes what the citizen journalist has the same rights as regular journalists. And based on this bill, they tell you what a cover journalist is. So if you're a blogger or an independent reporter, like like a natural born person, they say your report's null and void. And plus, when they want to subpoena you or ask you questions, that's called self-incrimination. Let's read the Bill of Rights here. Alright? From the U.S. Constitution. Amendment 1. Congress shall make no law respecting the establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right to people to peaceably to assemble and to petition the government for redress of grievances. This means government can neither impose a state religion upon you nor punish you for exercising the religion of your choice. You may express your opinions, write and publish what you wish, gather peacefully with others, and formally ask government to correct injustices. Does Senate Bill 987 supersede the First Amendment U.S. Constitution? Absolutely not. And here, actually, it infringes on the Fifth Amendment of our Bill of Rights, or under the U.S. Constitution. No person shall be held to answer for capital or otherwise infamous crimes unless a presentment or indictment of a grand jury, except in cases of arising in the land of or neighbor forces, or in a militia, or in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice be put in jeopardy of life or limb. Nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law. Nor shall property be taken for public use without just compensation. It means no one outside the military may be tried for a serious crime without first being indicted by a grand jury of citizens. Once found guilty, a person may not be tried again. Not guilty, the person may not be tried again for the same deed. You cannot be forced to be a witness or provide evidence against yourself in a criminal case. You can't be sent to prison or have your assets seized without due process. The government can't take your property without paying market value of it. So, another smoking gun. And it will hit the Ninth Amendment. The enumeration in this Constitution of certain rights shall not be construed to deny or disparage others retained by the people. You have more rights that are specifically listed in the Bill of Rights. That means natural law. Declaration, this amendment is more like a revised or summarized version of the Declaration of Independence, which Thomas Jefferson wrote. And it says here, the powers not delegated to the United States by the Constitution or prohibited to the states are reserved to the states respectively or to the people. The U.S. government means that the amendment, U.S. federal government has only those specific powers granted to by the Constitution. All the powers belonging to the states or to individuals. So right there, they want the 9th and 10th Amendment to be abolished, but however, thanks to technology and information, we are pushing back. So, I know I'll try to get a few more titles in here. However, I may do that in my next episode. But, how I see this Free Flow of Information Act is nothing more than a rhetorical deception. Okay? And those yahoos that co-sponsor it, especially Chucky Boy Schumer, I call him the Pinocchio of the U.S. Senate, because he is one pathetic man. Alright? I'm a real lawyer. All these people, I'm a real lawyer. I know more than you. Well, too bad. Our Bill of Rights culture supersedes your acidine referendum. And one moment here. I'm just going to try to, I know we may be talking out a little bit. Bear with me. I'm just trying to grab one of my books. Yeah, I got it right here. I'm going to do a little quick page on freedom of the press, if I'm correct. Yeah, see if they have it in here. I'm just gonna do a little checkout. But the fact is, my friends, they believe that you guys are just plain pathetic. Okay, they don't care what you think. All right, they want you to be just a bunch of yes people. Go, yes, boss, everything fine, boss. You know, okay, boss. So yeah, okay. I'm going through this book, The Real Thomas Jefferson, and he has some, Thomas treasures from Thomas Jefferson. And I'm gonna one little quote. I am salting here at the time being. I should have had this first. Oh yeah, it says here. Yep, right over here. Yeah, let me just check this out. Press freedom of abuse. The firmness with which people have withstood the late abuses of the press, the discernment they have manifested between the truth and falsehood, show that they may safely be trusted to hear everything true and false, and to form a correct judgment between them. That's in 1804. Alright? Let me just do, this would be perfect. Press, the Constitution and the freedom of the press. It is true that as a general principle, and is also expressly declared by one of the amendments to the Constitution, that the powers not delegated to the United States by the Constitution or prohibited by the states are reserved to the states respectively or to the people, and no power over freedom of religion, freedom of speech, or freedom of the press being delegated to the United States by the Constitution nor prohibited to the states, all lawful powers respecting the same did right remain with and were reserved to the states or the people. Thus was manifested their determination to retain to themselves the right of judging how far the chasteness of speech and or the press may be abridged without lessening their useful freedom, and how far those abuses which cannot be separated from their use should be tolerated, rather than the use be destroyed. In addition to the general principle and express declaration, another and more special provision has been made by one of the amendments to the Constitution, which expressly declares that Congress shall make no law respecting an establishment of religion, or prohibiting free exercise thereof, or abridging the freedom of speech or the press, thereby guarding in the same sentence and under the same words freedom of religion, of speech, and of the press, insomuch that whenever violates either throws down the sanctuary which covers with others, that libels, falsehoods, and defamation, equally with heresy and false religion, are withheld from the cognizance of federal tribunals. He wrote that in 1798 under Kentucky resolutions. Okay, my friends, that's enough for the day. I will post this link on my Spreaker page as soon as possible, including the Bill of Rights, alright, which is under the JPFO, Juice for Preservation of Firearms Ownership. And you can hit me on Facebook, Twitter, YouTube, Tumblr, and Spreaker. Call your congressman everywhere in the United States. Say hell no to this treasonous bill, both Senate and House. Alright? As always, demoniac resistance is healthy for the soul and can liberate societies. Till next time, take care of yourselves, keep on spreading the love, and may our guardian spirits be with you.